What you will see in these official videos launched an investigation into personal corruption by the Tennessee State Legislature's Fiscal Review Executive Director, Lucian D. Guise, who personally, willfully, and maliciously reviewed and certified as, quote, being true and correct to the best of my knowledge, outrageous fraudulent fiscal notes for proposed bills that he opposed, killing bills he opposed because they could not pass and the state budget remained balanced as required by the state constitution, effectively robbing citizens of the honest services of their government. Did Lucian Guise act alone or in conspiracy with persons in power? Our investigation will expose it all.
Good afternoon, everyone. We'll call the Senate Commerce and Labor Committee to order. Madam Secretary. Good. Thank you, Speaker. Senator Somerville is here. Members, we'll go to item number 8 on our calendar, Senate Bill 2450. And we do have a gentleman here who has traveled to be with us to present on this as well. So, Senator Somerville, we'll allow the room to...
Sure.
You cleared the room.
I did. I'm good at that. In fact, I have a hard time filling a room.
I have the same tendency sometimes, I think. So, all right. Senator Somerville, you are recognized. Item number 8 on our calendar, Senate Bill 2450.
Thank you, Mr. Chairman. I know you've had a long afternoon and a lot of intricate matters before you, and I'm not going to wear your patience. Senator Johnson, Chairman Johnson mentioned my friend Lily Johnson, who is here today. Lily is a constitutional expert. He's taught me more about the Constitution than I ever learned in school, especially with reference to the promise and guarantees in the Constitution of state sovereignty. They're embedded in the Constitution, and they've been recognized over the years in significant court decisions throughout most of American history up until relatively recent times. Now, even though Chief Justice Roberts voted to uphold the ACA, he had a famous dictum in his decision. He said the states are separate and independent sovereigns. Sometimes they have to act like it. Mr. Chairman, Lily Johnson knows more about this aspect of our glorious Constitution than anybody I've ever met. I'd like him to give you a brief statement in a minute or two. I think we've all come to terms with what we're going to do with the bill today. It has a ruinous fiscal note on it, impossible to consider. But if we roll it to the last calendar, I think we'll take a look at that again, see if anything can be done. Perhaps it can't. But I want to give a chance to my friend, my constituent, to be heard about that in 2 weeks. With your permission, sir, could Mr. Johnson come forward and...
Absolutely. Thank you, Senator Somerville. And without objection, we'll go into recess, and I'll take a moment of personal privilege and say Louis is a dear friend and one smart cookie whenever it comes to the United States Constitution. And I don't want to steal Mr. Johnston's thunder here, but it's a fascinating constitutional concept, I guess is a good way in terms of interposition, and it's something that our framers did talk about. And to set the stage and to echo what Senator Somerville said, what we have agreed to do is to, similar with the last bill, is have Mr. Johnston give us a 10 to 15-minute presentation on what he has come up with. Our Fiscal Review Department has treated this bill very similar to the way they did Senator Beaver's 1888, I think is what it was, which also dealt with the Affordable Care Act. And in terms of asserting that this could jeopardize our matching funds in TennCare and also potentially subject us to fines and penalties amounting to a significant amount of money. So, but I thought it certainly was worthy of this committee's time to hear about the idea, the concept, and then again, as Senator Somerville said, what we'll do is perhaps circle back with fiscal review and see if we can have some conversations with that. So, Louis, we've already mentioned your name, but it is a matter of practice. If you would please introduce yourself for the committee, and you're recognized for your presentation.
Thank you, Mr. Chairman. I'm Louis E. Johnston.
And make that microphone bright green.
I got it. Thank you, Mr. Chairman. I'm Louis E. Johnston, Jr. from Nashville, Tennessee, and I thank Senator Somerville for the honor of addressing you today, and it won't be long. It'll be short, but I hope to be able to be back in a couple of weeks and address the fiscal note, which is atrocious. And with note, it's almost a scary thought that a $32 billion that a bill that I present to defend the citizens of the state of Tennessee could cost $32 billion. That's every NFL team, every Major League Baseball team, and a couple of NBA teams thrown in there to boot just to defend our state citizens. Maybe something's wrong with that, and it's called federal tyranny. And if you find that this is an economic issue, then we're framing it the entire wrong way. Interposition goes back to the House of Delegates, which is before the Constitution. And James Madison said very clearly that this assembly doth explicitly and peremptorily declare that it views the powers of the federal government as resulting from the compact to which the states are parties as limited by the plain sense and intention of the instrument constituting that compact as no further valid than they are authorized by the grants enumerated in that compact, and that, in case of a deliberate, palpable, and dangerous exercise of other powers not granted by the said compact, the states who are parties thereto have the right and are in duty bound to interpose for the arresting progress of the evil and for maintaining within their respective limits the authorities, rights, liberties appertaining to them. That's the basis from which I'm coming to you today, is even before the U.S. Constitution goes back to the House of Delegates. I'd like to take you directly to the bill itself. Well, let me do this. First of all, I want to assure you that if I come back and I'm able to speak to you about the fiscal note, I will be able to address each and every point of it. But I do want to address the first point of it right now. It's already a Class D felony in TCA 3917-309 for civil rights intimidation. And the violation of civil rights of the people carries a Class D felony. Our bill asks for a Class E. So I'm saving money there if it comes to that, since it's less penalty. But to stand up and have enforcement for the people of Tennessee instead of letting the federal government roll over us, it's going to be costly. If you put people in jail, it'll be costly. There's no question about that. That's not our intent of this bill. Our intent is to have enforcement teeth that will curtail and prevent people from rolling over the civil rights of our citizens. Now, in the preamble section of our bill, I'd like to quote you a couple of things from Prince versus United States. The Supreme Court of the United States ruled, we held in New York, and this is, by the way, something that Justice Roberts quoted also in his Sebelius Act. We held in New York that Congress cannot compel the states, I want to make that clear, Congress cannot compel the states to enact or enforce a federal regulatory program. Today, we hold that Congress cannot circumvent that prohibition by conscripting the state's officers directly. Then I want to go to Section 3 and quote from the bill. It is the intent of the General Assembly that this act codify the sworn duty and process of this state to interpose, to prevent usurpation or encroachment upon this sovereign state and its citizens by the federal government with respect to the Patient Protection and Affordable Care Act in violation of state rights and intrastate commerce, culture, federalism, and the constitutional rights of the state's citizens. Now, Therefore, members of the committee, it becomes a simple fact that we either believe that Obamacare violates the citizens' civil rights of this state, or it doesn't. Now, in Section 4, I list clearly 10 illegal and unconstitutional actions of Obamacare, where it's clearly unconstitutional and illegal. Now, since the Supreme Court has already ruled that Congress can't do that and enforce it, then it's incumbent upon you as the state legislature to defend our citizens against this encroachment. That is the premise I have today. And that is the issue. If you believe in Section 4 that I've laid out the defense and the illegalities and the constitutional transgressions, then maybe the cost is the cost of capitalism versus the cost of socialism, because that's what we're faced with. Obamacare is pure socialism. I don't think there's any question about that, particularly if we read this. Now, by the way, this didn't just come from my head. I collaborated with the governor's staff in Louisiana, Governor Jindal's staff, to get these down to these 10. I had 31 illegal and unconstitutional actions, but that seemed to weary everybody. So we're just on these 10. I would say we have a decision to make on this bill, HB 2450. Do we believe that the Obamacare Act, the PPACA, is a violation of the civil rights of the citizens of the state of Tennessee? If it is, who better to defend the state citizens than the Senate Commerce Committee? Who best to defend our citizens from the encroachment and usurpation of our intrastate commerce, of our culture that we know and these gentlemen spoke so well to? It's different. I designed the Blue Cross Blue Shield healthcare system. In my former career, I was a consultant, and I see the gentleman with the AmeriGroup was here, and I was hired by AmeriGroup to blueprint 7 states, the systems in 7 states that rolled up into their Virginia headquarters. I have a unique skill set in healthcare and in constitutional areas. The issue of our state is so special that you have to design different systems for Memphis and for Jackson and for rural counties than you do for urban areas and the big cities. And there's no one size fits all. Every need is different. There are different amounts of providers, as they well said. But if we allow this PPACA to continue, then they're going to dictate what the doctors make and what people can charge. And already, I'm aware of some cases where surgeons are paid less than the cost of for a surgery. They're paid less than the cost that a dental hygienist charges to clean your teeth. It's just ludicrous for us to lose our civil rights and our options. And I just want to finish close with this. This is a quote from a fellow that Leopold Schwarzschild in 1944. He actually died in 1950. He was a distinguished journalist and editor and opponent of rising German nationalism, and he was thrown out of Germany by Hitler's government. Just like to close with this. It is difficult for the human mind to imagine things which it has not seen. For the inhabitants of a free country, it seems almost impossible clearly to understand the process through which freedom is lost. One must have personally witnessed it once in order to realize its nature. As a rule, those who have never witnessed it always remain too innocent about it. They think of the conditions to which they are accustomed. It can't happen here. Why should anything change much? The state will become the sole owner of everything, but for the rest, so people imagine, everything will remain as it is. The old institutions and mechanisms, the Constitution, the Bill of Rights, Opposition, parties, elections, parliaments, courts, all this will continue to function the day after socialism, just as it did the day before. What a delusion. Everything can change. The single fact that everybody's bread is in the power of the government sterilizes all these institutions and mechanisms, even if they continue to exist in name. The right to speak against the state is of no value if no one dares exercise it. Mechanisms for the control of the state are of no value to the people who are the life of these mechanisms, are compelled to behave in a servile fashion. From the moment this monopolistic power falls into the hands of the state for the first time, the people who will then be entirely dependent upon it will become more and more cautious. The moment the guillotine of the withdrawal of subsistence falls on the necks of a few overbold dissidents, the sclerosis of the political organism will set in. The blood which is still flowing through its old veins will be poisoned by fear. The body will no longer move, but will be moved. And once things have gone thus far, there will be no obstacle to transforming it at will, even the nominally subsisting institutions and mechanisms, the constitutions, the Bill of Rights, and laws. Freedom will be lost. The blackout will descend. But my government will not do this, replies the optimist. It will be a government which I myself have chosen and put in power. It will be composed of people whom I know, who all their lives have fought for the cause of the people and for freedom. I can entrust my welfare to them without fear. And I close with that. The citizens of Tennessee can entrust their welfare and their defense of their civil rights in this matter to the Senate Commerce Committee, where it belongs. Thank you, Chairman.
Thank you, Mr. Johnston. Good afternoon, everyone. The Senate Commerce and Labor Committee will come to order. Madam Secretary, take the roll. Okay, members, so we will now go to the calendar, and I see Senator Beavers has joined us. Item number 1, Senate Bill 1888. This was rolled from 2 weeks ago. Senator Beavers, good to have you with us.
Thank you, Mr. Chairman. As you know, this is the bill that has to do with Obamacare. It is called the Health Care Freedom and Affordable Care Noncompliance Act, and provides that the state of Tennessee will not use any...
Mr. Chairman, is
the microphone on?
Is your microphone on?
I think it is.
It is.
Oh, much better. Thank you.
I guess it was just too far to the side. Under Supreme Court cases, it is clear that the federal government cannot come into a state and commandeer state employees in order to enact federal legislation. In Prigg versus Pennsylvania, the court stated the states cannot therefore be compelled to enforce them, talking about federal laws, and it might well be deemed an unconstitutional exercise of the power of interpretation to insist that the states are bound to provide means to carry into effect the duties of the national government nowhere delegated or entrusted to them by the Constitution. That quote was from Justice Story. New York versus United States. Sandra Day O'Connor wrote, Congress may not simply commandeer the legislative processes of the states by directly compelling them to enact and enforce a federal regulatory program. And then in Prince versus United States, where Sheriff Mack actually sued the federal government over the Brady Bill, Justice Scalia stated, Congress cannot compel the states to enact or enforce a federal regulatory program. Today we hold that Congress cannot circumvent their prohibition by conscripting the states' officers directly. The federal government may neither issue directives requiring the states to address particular problems, nor command the states' officers or those of their political subdivisions to administer or enforce a federal regulatory program. It matters not whether policymaking is involved in no case-by-case weighing of the burdens or benefits is necessary. Such commands are fundamentally incompatible with our constitutional system of dual sovereignty. And then if we just skip on over then to independent business versus Sebelius, we find that the court ruled that the federal government cannot force the states to act against their will by withholding funds in a coercive manner. Justice Robert Kennedy, for the court plurality, argued that allowing Congress to essentially punish states that refuse to go along violates constitutional separation of powers. Mr. Chairman, I know there is a large fiscal note on this bill, and that's why I wanted to read those quotes from Supreme Court cases, because I think that when you read those quotes, it makes this fiscal note sound absolutely ridiculous. The fiscal impact says, things to the effect the state could incur penalties, the state could reduce fee expenditures. If the federal government makes a determination that the state is non-compliant with federal law. Well, Mr. Chairman, ladies and gentlemen, we don't have to do the state exchanges. And it makes sense that if your bill prevents something from being done, there should be no fiscal note on this bill. They also go on to talk about that they could actually have money taken back. We could have to reimburse approximately $10,277,300 for the funds already received by the state. When was the last time that we remember the federal government actually taking money back from a state? I think that this fiscal note is unfounded. It refers to penalties, to fines that might occur. We passed the Healthcare Freedom Act in 2011. That was the first bill that this governor signed when he came into office, saying that if the federal government should come to Tennessee and try to fine individuals, that our Attorney General will defend them. With that, Mr. Chairman, I don't know if you want to hear from Fiscal Review on this, but that would be my argument on this bill.
Okay, we're happy to do that, and we've asked for a Fiscal Review to be here, and certainly happy to entertain those questions or hear comments from them. If there's no objection from the committee, we will go into recess to hear from Fiscal Review. And I might point out we're pleased to be joined by Senator Somerville, who is in the gallery as well, and he had a bill that had a very similar fiscal note. Now, that bill is not on this week's calendar, but I just want to point that out because his took a different approach with regards to interposition, but there were similarities, I think, and certainly similarities in terms of the fiscal note. So I just point that out to members that some of this testimony from Fiscal Review may be relevant. So without objection, we'll go into recess to hear from Fiscal Review. Mr. Geist?
Thank you, Mr. Chairman. Lucian Geist, Director of Fiscal Review Committee. As I understand our statutory duty for each bill that's filed before the General Assembly, Fiscal Review staff is to try to assess and quantify the fiscal impact that the legislation would have on state and local government. And we do our best to do that. We first give departments an opportunity to tell us how the bill would affect their current operations and what it would do to their operations fiscally. And then we analyze those responses. We conduct additional research to the extent we can, and then do our best to communicate what we have found out to you in the form of a fiscal note. Most of the time, we're able to quantify either increased or decreased revenue or increased or decreased expenditures, and we try to lay that out in dollars and cents for you all. Sometimes there is a contingency or some occurrence that we're not able to determine will or will not happen, or some additional information that we want to impart to you. And that's what happened in the case before you. and I'm happy to talk about this a little bit because I think there's some confusion about what we're trying to communicate. In this instance, we estimate the fiscal impact is an other fiscal impact, that if the federal government makes a determination that the state is non-compliant with federal law, there could be a number of fiscal implications. So based upon what TennCare, several other departments have told us, the provisions of this law would put us out of compliance with federal law, and they have the ability to do something to the state to either rescind money or have the state incur penalties. And we've had to lay out what those penalties are if, in fact, that contingency happens. So it's not necessarily a direct cost to the state or a direct number of revenue to the state, but it is an other fiscal impact that we try to communicate to you all as you consider the policy implications of the bill.
Okay. Members, questions for Mr. Geis? Vice Chairman Green.
Yes, sir. Could you kind of explain the 32, I guess that's 32 million in penalties? I'm sorry, billion.
Sure.
With a B?
Okay.
Yeah. Could you explain those for me?
Sure.
Thanks. Close, right at the state budget, right? 100%. Yeah.
Senator Green, I think that $32 billion figure is in the middle of page 2, starting with according to Benefits Administration. According to Benefits Administration, there are 6 mandates in various sections of the PPACA that the state-sponsored health plans would not be in compliance with and could receive a $100 per member per day penalty, resulting in penalties of at least the $32 billion figure. Further, in addition to the previous 100 per member per day penalties, the state could incur an additional per member per day penalty for dependents who would no longer be covered. So I think that portion is related to what Benefits Administration would potentially incur regarding state employees' health coverage and local government employees' health coverage, if the federal government determined that we were not compliant and sought additional penalties for us.
Anyone else for Mr. Geis? Okay. Senator Beavers, would you like to respond?
Well, he says if the federal government were to find that we were non-compliant, well, so far we have not chosen to do the state exchanges. So how could we be not compliant if we haven't chosen to do it? And it's very clearly outlined that we don't have to do the state exchanges.
Speaker Watson.
And this may be semantics, but we don't have to build the state exchanges. That's correct, and we've opted not to do that. But the exchanges themselves have to be made available to the individual citizens. We've chosen the federal model to do the exchange. So we can say we're not building a state exchange, but that still doesn't mean that the exchange doesn't exist. And I'm trying to understand the $32 billion. If we prohibit, and maybe fiscal review if they need to step up, if we prohibit individuals from utilizing or accessing an exchange that may be built by the federal government, then we are subject to a penalty per day per member that is prohibited from utilizing the exchange. Is that what I'm hearing you say, Mr. Geis? So it's not. I mean, it's true. We can say we're not building the state exchange. We've said that, but we've opted the federal exchange. And I think what Mr. Geis is saying, if I hear him correctly, is that the federal law requires us to allow individuals access to that federal exchange, and failure to do that is a penalty for being in violation of federal law. Is that what I understand you to be saying, Mr. Geis?
In a sense, Speaker Watson, I think that the ramifications are larger than the exchange component of the Affordable Care Act. It's the entire directives of the Affordable Care Act, including the exchange component, but there are other requirements that the state must adhere to.
Well, I guess I was referencing into the sponsor's specific point around the exchanges. To say the state exchange, and maybe the sponsor can help me clarify, when you're using the term state exchange, are you referring to the state's construction of an exchange, that is a state-managed or a state-built exchange, versus that the state has an exchange, which in our case is the federal model? That's what we've chosen to use. And I don't know if I articulated that correctly, but when you say the state exchange, are you referring to the state-constructed exchange, or are you referring to an exchange that is in a state, which is what we have, a federal exchange in our state?
An exchange that is in the state, I think. Well, let me say this. I'm referring to the state exchanges, that they cannot commandeer our state employees to actually put into effect Obamacare. But Section C of the bill says that this section shall not be construed in any way to prohibit any person from purchasing insurance from a federal health care exchange, or to invalidate any existing or future health insurance policies purchased from the federal exchange.
Speaker.
Okay, so help me understand who's being commandeered here. I guess I don't understand that component of it. If you're saying that the federal exchanges are in place, that individuals have access to purchase on those federal exchanges, who's being commandeered?
Our state employees is what we are asking you to do in this legislation, is to prevent our state employees from being commandeered and used to enforce a federal law.
Okay, again, and I'm sorry, Mr. Chairman, I'm having difficulty understanding the definition of commandeering, I suppose. What does that mean? Who is being, for lack of a better term, conscripted to what state employees are you referencing?
Any state employee that might be used to enforce or implement Obamacare.
So if Mr. Chairman?
Speaker.
So if a employee is working in TennCare, a state federal program, and a change from the Affordable Care Act affects TennCare, your argument is that we cannot require that employee to carry out that function within TennCare.
I guess according to what this legislation says, that would be the case.
But TennCare is a federal-state partnership, and in that partnership, don't we assume certain parts of it, and they assume certain parts of it, and our employees carry out that partnership?
That's correct, but we're talking about in this legislation the expansion of the Medicaid program, or anything that is done by our state to implement Obamacare, whether that includes.
Well, I'm sorry, Mr. Chairman, and I'm sorry to be drilling down like this, but I'm just trying to understand so that I can understand the fiscal note that they've referenced. But if you're just referencing Medicaid expansion, that's only one component of the Affordable Care Act. And the quotation that you used from the NFIB Sebelius is in reference to that specific aspect of the Affordable Care Act. It's not in reference to the total Affordable Care Act. It's just saying under expansion, states cannot be penalized. So if you're just referencing expansion, but your bill seems to be broader than that, and certainly seems to be interpreted to be broader than that, is the point that I'm trying to make with this. I don't disagree with what you're trying to accomplish, but I think the concern that members of this committee might have is the broader implications of that, the broader implications of a federal-state partnership that's in the Medicaid/TennCare program and what the financial impact of that would be to the state. And I'll yield to other members, Mr. Chairman. I'm sorry I've taken too much time.
Thank you, Speaker. Senator Green.
Yes, thank you, Mr. Chairman. Senator Beavers, on this bill, the language concerned me initially. I mean, I wanted to support this, but what concerns me is the broadness of it. I'll give you an example. One of the things that I'm aware of is in Maryland and in Texas and several other states, the navigator organizations have gone in and committed fraud. I mean, they basically have done some egregious things. In Texas, they're actually cooperating with certain political parties to get candidates, elected. It's atrocious what's going on. Last year, we passed a bill that allowed our Commerce and Insurance Department to regulate and track those navigators, hold them accountable to our Tennessee laws, do background checks, things like that. I'm concerned that this basically tells our state employees that they can't any law, and I went and sought legal counsel, and they agreed. We would basically be saying we have no oversight of these navigators who are in our state executing the federal exchange. We have no choice but to allow Tennesseans to participate in based on the Supreme Court hearing. So understanding that fraud is happening across the country, understanding that I would love to continue to see the state's ability to regulate these navigators and things like that, I don't know that as it's currently worded, I'm going to be able to support your bill, and I just wanted to let you know that.
And I would welcome the input of this committee. I think you know what we're getting at on this. I think it's astonishing to think that, we have so much money invested in the Obamacare anyway, apparently, from the questions asked by Senator Watson. I would welcome any language that this committee could come up with. If you want to say that we have to vote on it before the administration could accept any of the Obamacare requirements, I would accept that. I'm comfortable with the language that I have here, but I'd be glad to work with you to come up with some other language that you think would cover the concerns that you've come up with today.
Mr. Chairman, I just want to agree with, and make a brief statement about the intent. I disagree with the wording of this bill, but I understand that. I'm concerned about what the federal government is doing by taxing us, which Justice Roberts said they could do. They could take all the tax money they want and then trickle that money back to us when we comply with their federal programs. It is, in a sense, an undoing of federalism. It is scary what's happening. I don't know that this fixes that, but I'd like to find a way to. But I want to be on record. I understand what's trying to be done here, but I'm not sure we're getting there with this. But it's pretty scary, the end around to federalism that has occurred with this federal government in the way, whether it's road dollars, healthcare dollars, even DCS. If we want to pay to do placements, we have to do it the way the federal government says to get that money. It's a little bit out of control. I just wanted to be on the record saying that.
Well, one thing, and again, Senator Somerville joins us and has a similar bill that we had last week in committee and had some testimony on. And I guess if there is a silver lining, and I think it should be reflected, we're not the only state that is trying to figure out a way to mitigate the impact of this disastrous federal law on our citizens. And so I certainly applaud you, Senator Beavers, for trying, and Senator Somerville, same thing. But the fact is, if we vote this bill out and it goes to finance, it's dead on arrival in its current posture. And I think that that's an important thing for us to realize and contemplate. And while it is not the purview of this committee to consider fiscal impacts, we do typically, as a courtesy, try to take that into consideration before we send bills off to the Finance Committee. And we have time. And I appreciate Senator Beaver's willingness to try to figure out a way to get as much as we can done to effectively protect our as Vice Chairman Green said, to protect the citizens of Tennessee from this overreaching federal government. And at least I think a preponderance of this committee would be in full agreement on that. So perhaps, Senator Beavers, we could roll this, and I don't know if you would like to maybe consult with Senator Somerville. Your bills take slightly different approaches. The interposition idea, I think, is a unique one, but to further consult, I know Senator Beavers, you had been in contact with a couple of other states that were considering this as well. I think one ended up with a similar type of fiscal impact statement on theirs, and I know you've been working with some outside organizations too with regards to this. So, the committee, I'm sure, is happy to give you some time, and the same with Senator Somerville. I believe we've rolled his to the last calendar as well. So, Speaker Watson, were you seeking recognition?
Both of these bills have really, taking away the content of them, they have highlighted the challenge that states have, and Tennessee's not unique. I mean, when you get a fiscal note that has a $32 billion potential risk to it, you begin to realize the reliance that the states have allowed themselves to acquire with the federal government. And it should be somewhat of a message to us that when we consider legislation here that's relative to federal funding, that those strings can be quite significant. And the Medicaid Act goes back to the 60s, and over that period of time, as Senator Green will know, we've seen health care become more and more tied to those federal dollars, and we've implemented more and more things over the years in order to maintain those federal dollars. We see the same thing in education. We see the same thing in transportation, where the federal government has rescinded funded to the states to the tune of about $281 million to the state of Tennessee. And so, the more dependent we allow ourselves to be to a federal system, a federal government system, then the more these kind of challenges will present themselves. And if anything at all has been accomplished by this, by Senator Somerville and Senator Beavers, is I think the startling recognition of how at risk we are when we try and do things a different way. And I applaud them for this particular issue highlights it, but the bigger message is our reliance on a federal government that doesn't always see the world from the same prism that we do. Thank you, Mr. Chairman.
Okay. Senator Beavers, your pleasure.
Mr. Chairman, I just wanted to say thank you, Senator Watson, for pointing that out. But if you listen to all of these Supreme Court decisions that have come down over the years, all the way back to 1842, all the way to the present, we've got to give some serious thought not only to voting in these programs where we get federal money, but to standing up to the federal government to say, you're not going to tell us what to do. Because they do this in many, many instances when we receive this money. And our state employees end up being the ones that we have to pay to implement federal programs, when clearly the case law is from the Supreme Court all down through the years that the federal government cannot do what they're doing. But until the states stand up for our rights and tell the federal government you're not going to do this, they're going to keep doing it, and we're still going to be sitting here still accepting what's going on and making excuses with fiscal notes of why we can't pass a bill. Thank you, Mr. Chairman, for the time, and I'll see you next week.
Okay, 1 week. Good afternoon, everyone. The Senate Commerce and Labor Committee will come to order. Mr. Clerk, take the roll. If there's no objection, item number 25, which is Senate Bill 2450, the State Interposition Act, and we'll wait on that. And I don't know if Ms. Harden is in the sound of my voice, but we have the amendment. If you can hear me, we're in good shape on that. So I think she went to make copies of it. So,
yes, that's right.
Okay, Senator Somerville, you're recognized on 2450.
All right. As I say, sir, I brought back Mr. Johnston, who would like to address specifically the concerns about the unacceptable fiscal note, which is, as I say, a sort of what if various things happened, if you'd recognize him.
Okay. If there's no objection, we'll go into recess. Mr. Johnston, if you'll come forward. You've been with us before, so you know the drill. Make sure your microphone is on and introduce yourself for the record, and you are recognized.
Thank you, Mr. Chairman. Am I on?
You're on.
Thank you, Senator Somerville. I appreciate the opportunity to speak to this to the members, and it will be very, very brief. The fiscal note says if the federal government makes a determination that the state is non-compliant with federal law, there could be a number of fiscal implications due to a number of unknown factors, including the federal government's determination, and when any penalties or fund revocations would occur, the exact fiscal impact cannot be determined. Now, I want to take issue with the fiscal note, and that it's an error. The federal government will not make the determination. It'll be the Supreme Court of the United States, because if you enact this law, then our law has to be overturned, has to be challenged first by the executive branch, and has to be overturned. There is no process or protocol in the PPACA to collect penalties or fines from the state. It says that they can happen, but there's no protocol or process to collect them. There's no vehicle by which to collect penalties and fines. And this is a list of possibilities. It's a fiscal list of possibilities and not a fiscal note. I don't know how to refute possibilities, and I don't think anyone else does. I would like to say this, though, and I've left some of you with some of this information that Governor Bredesen left with us, and he says that the PPACA is a 76% federal subsidy for a typical family of four with a median income of $50,000. That $20,000 premium is going to be subsidized by the federal government at 76%. Now, I know it's very attractive, Mr. Chairman, for the state government to cut their expenses for the employer share, as Governor Bredesen says, might save $146 million for the state government, but you're going to cost the people, the citizens of the state, $44 billion, because they're the ones that's going to bear that 76% subsidy that the federal government's charging. And I maintain that the fiscal note is in error because it does not have any process or protocol whatsoever to collect penalties and fines, and it's determined on the fact that we have to lose our case. If you enact this law, well, first of all, if you don't believe that we have a good case here, then you shouldn't vote for this bill. But if you believe that we've got 1 out of 10 chances, and we've listed 10 solid constitutional illegal grounds of transgressions that the federal government's making on the state of Tennessee and our citizens. We've listed 10. All we have to win is 1 because we have a severability clause. We have to bat 0 for 10. The Supreme Court would have to say that we are without merit on any of our 10 lists of grievances. Just 1 will uphold the law. In that case, Mr. Chairman, there can be no penalties and fines because our interposition is going to be effective. Now, I maintain it's the Commerce Committee that has to judge. Who is going to determine when the federal government comes to encroach on our state rights and citizens? Who's that going to be? There's not going to be a court. This is the court to represent the citizens. This is the court to determine if they have crossed the line and encroached upon our state rights and citizens' rights. If they have, we're depending on you to vote to uphold the rights of the citizens and interpose between the citizens and the federal government. Let the Supreme Court do their thing if it comes to that. If we go 0 for 10, then there could be possible penalties and fines somewhere down the road, but there'll be plenty of time to take action to correct that before those penalties could take place. Because, again, there's no process or protocol for collection of penalties and fines through PPACA. Thank you very much.
Thank you, Mr. Johnston. I have a quick question, Louis, Mr. Johnston, I should say. I can follow your argument on the penalties and the fines, but on the what's effectively our Medicaid matching funds, which is another element that's in the fiscal note. And I can't speak with any great authority on that, and I don't know that we necessarily pursued this with fiscal review. I know the administration's here, and they could speak to it as well. But that's roughly $6.5 billion, and I'm yielding to Speaker Watson from Finance Committee to see if I'm using the right line item that is there. The argument about if this made it to the Supreme Court, I could see on the penalties and fines to local government and state government. But we deal with as a state, and Speaker, anyone else, feel free to chime in on our Medicaid compliance, if you will, on our 2-to-1 match, 3-to-1 match, whatever it is with Medicaid. And they're pretty strict about that, and I can't cite you a specific example where they've ever withheld Medicaid funds from us, but I'm willing to bet that has probably happened, if not in Tennessee, in some other state. But that's not so much an interposition issue or in terms of trying to protect our citizens against the harmful effects of Obamacare, which I'm all for, but in terms of being compliant with Medicaid or non-compliant and potentially jeopardizing that $6.5 billion roughly figure that it is there. Can you speak to that?
Yes, sir, and thank you for bringing that question up. It's a very good one. The fact is, Justice Roberts already ruled in his Sebelius case. His opinions said clearly that the federal government cannot force the states to expand anything, and they cannot use their current funding as a stick and carrot or as a whip, either way. So it's already been ruled that they cannot penalize the state for failing to expand in any area. They can dictate terms and conditions of what they're already giving us. They have the right to do that, but they do not have the right to withhold funding for some other reason, just to make us, to force us to do what they want us to do.
Well, and I would follow, and I agree with you on the Medicaid expansion, but CMS does frequently make changes to their guidelines, or what states have to do to be compliant, and there were elements of that in the Affordable Care Act, rightly or wrongly, that didn't have anything to do with the Medicaid expansion that I believe Chief Justice Roberts was speaking to, but just in terms of the day-to-day compliance of Medicaid in that regard. The argument may still hold. I don't know if it does or not, but I just know they're constantly sending down new guidelines, and now we're going to make you do this or do that. And if you don't do it, it has nothing to do with new money, but your existing Medicaid money. It could be in jeopardy, and it drives us all crazy that they jerk our chains like that, but they still do. And I'm trying to draw a distinction here between existing Medicaid and Medicaid funds versus the expansion or a penalty associated with possible expansion.
I understand, and I understood your question to be what happens to funds down the road.
Sure.
It's not the existing funds that you asked the question about that I understood.
Well, no, it's in the fiscal note. It's the state could incur, or the state could reduce. Oh, I'm sorry, I lost it here. Bear with me. The exact fiscal impact: federal funds in the amount of $6.5 billion could be jeopardized.
Could be.
Could be exactly to your point. I read that as, and I don't know if fiscal review's here, but I read that as being our existing Medicaid funds. And like I said, the argument may still hold. Other members have thoughts or comments for Mr. Johnston? Speaker?
Question. Can you give me an example of where the theory of interposition that you're promoting here today has been applied and successfully implemented?
I would maintain that the current drug laws in some of the western states are more interposition with respect to being able to regulate marijuana, for example. It's not called an interposition act, but it's a way of regulating that the federal government could come in and still maintain that they could take action against people that are committing illegal acts, but the state has went around that and interposed on behalf of the people to do things they want to do in their state. We don't want to do that here, but they have done that. And no, I cannot tell you of a single state that has passed an interposition act yet, if that's your question.
Yeah, that was the question, because it's similar to theory of nullification that people have argued about since the Constitution was written. And so I was just curious, since there's never been a successful nullification, I was curious as to whether there had been a successful interposition.
Thank you. Could I address that?
You're recognized, Mr. Johnson.
And thank you very much for bringing that up, because nullification is so far different than interposition, and here's why. Nullification, you're taking a stick and you're poking it in the eye of the Supreme Court and saying we're not going to go by your law no matter what you say. Interposition is recognizing that Tennessee is a part of an honorable contract. And we made that contract in 1796 when we entered our Constitution, entered into the United States Constitution as a party to the contract with 13 other states, and now with 50 states. We're one of 50 states that's a party to this national contract. Now, the only honorable and legal way to resist federal tyranny, according to Justice Roberts in his rulings, is to have a list of grievances codified and let we have to resist the federal government whenever they encroach or usurp upon the state rights or citizen rights. This is the only way legally and honorably to do that, is to make your list of grievances and say these are the illegal constitutional transgressions, and we're not going to allow you to come in and roll over our state or our citizens unless these are rectified. Now, at that point, it's not the federal government. It is the executive branch, or that has to go to the Supreme Court, and the Supreme Court has to look at our bill, our law, and then look at our list of grievances that we've laid out. And hey, if we're wrong, we're wrong. But if we're right, only one of them has to be right for them to uphold our bill.
Speaker Watts.
So you want us to move this bill forward so we can be a test case for interposition?
Well, for that and other reasons, but it's the value to the state of Tennessee, the citizens of Tennessee. If we don't interpose, who will? It's incumbent upon this committee to interpose if you believe that the federal government has encroached on our rights, and no one else is going to do it. Mm-hmm. There's nobody else to do it, and if you do that, then we can work with finance and figure out what their list of possibilities really means. That's another battle for another day, Mr. Chairman. I maintain.
But Mr. Chairman,
sure.
But it is a test case because there is no legal precedent for interposition.
There's no legal precedent for an interposition act.
Thank you, Mr. Chairman.
Okay, we're still in recess, but Senator Somerville, could I ask you to step up to the lectern, and Ms. Johnson, if you'll stay there as well. Here's our posture. I sometimes don't like our fiscal note process anymore. It's worked for me, and it's worked against me. The question for this body is, if we agree in spirit with the merits of the bill, do we send this to the Finance Committee with a $32 billion plus fiscal note, even if we disagree with the fiscal note? Our process up here, as members know, is we have an independent fiscal review committee, and they are autonomous and they're independent, and we argue with them. Sometimes we yell at them. But at the end of the day, when they attach a fiscal note, it is a fiscal note, and it has to be recognized by the Finance Committee. So we're in recess because Mr. Johnston might want to weigh in, or Senator Somerville may want to have him weigh in. I've got to say, I've told you I support the spirit of your bill. I support Senator Beaver's bill as well, 1888. It's got the almost identical fiscal note. It has been the long-standing courtesy when you have bills of this type that have significant fiscal notes that we don't send them on to the Finance Committee. I don't know to what degree or extent the sponsor has consulted with Fiscal Review. We had them in last week, I guess it was, to talk about the fiscal note. I will say, and I want other members to chime in on this. It gives me heartburn to send a bill with a fiscal note of this magnitude to Finance Committee, because there. To Mr. Johnston's point, there's really no negotiating with the Finance Committee. I mean, it's and Speaker Watson, I'm somewhat out of my bailiwick here because I'm not on finance and you are. I'm not sure about other members, but the real, I guess, discussion is with Fiscal Review, and will they modify or amend or reconsider the fiscal note? Are there changes that can be made to the bill? We go through this process all the time when we have fiscal notes on our bill. Are there things we can do? So I guess, Senator Somerville, do you have thoughts, your desire to take more time? Or Chairman Yeager, you want to chime in?
Is there anyone here from Fiscal Review that could speak to this?
We had them speak to it. Was it last week or was it 2 weeks ago? I can't remember. That we had Mr. Geist in here and 2 weeks ago. That
I recall that, but
that he spoke to it.
For at least me to have my recollection refreshed.
Well, I don't want to speak for Fiscal Review. My sense was that they were somewhat dug in on the fiscal matter. Senator Somerville, you're
No, sir, Mr. Chairman. I certainly defer to your and the committee's obvious consensus that this is not a good idea to send it on as it is. And I think you're also right; they're not going to change their mind. Fiscal Review is a great mystery to me. Some of my bills come back with inexplicable notes on them. I have no idea how they could have arrived at such numbers. We've all had that experience, though, so I'm not by myself. I do respect the fact that we don't take something to finance that's not going to be
well,
possible.
and I would say, and I think Senator Beaver's bill 1888 is somewhat in a similar posture. And I can't speak for the Finance Committee, but it's been my experience. They might send it over there, they put it behind the budget, and then it dies a slow, miserable death. I don't know. I haven't asked Senator Beavers recently on 1888 if she. I know at one point she was consulting with a couple of other states that were pursuing something similar. I don't think there is another state that's pursuing something as unique as this interposition idea. But I'm at the will of the committee. This is not our last meeting. If we want to consult, Mr. Johnston, I don't know if he's had a face-to-face with Fiscal Review. We could perhaps arrange that with Director Geist. We can take a vote. It's.
I don't really think a vote's necessary, Mr. Chairman. I think you're speaking of the consensus of the committee. If our expert here would like to talk with Fiscal Review and then come back one more time, that's okay with me. But I don't want to try the patience of this committee. You've been very good to hear this. Now, I will just add, in one sentence, some of these days, sooner rather than later, we're going to have to push an interposition bill. Sooner rather than later, ladies and gentlemen. It may have a cost attached to it, but it's going to have to happen. This may not be the bill. That day is coming.
Speaker Watson.
I do like the theory, and I do like the witnesses' explanation that perhaps some of the marijuana/medical marijuana bills strike at the theory of interposition. But given, unless we can do something with either the real or the potential fiscal implications of this legislation, given the current climate that we face budgetarily in this state, there's just no way that the state finance committee could take that risk, however small it might be. I'm not sure we would put, even if we were 90% wrong, we're still talking about several $billion hit to the state's bottom line. So I think that's the challenge. But I think this theory has much more merit than the nullification theory does. I like the approach to it. Thank you, Mr. Chairman.
And a couple of other things. And Mr. Johnston and I had spoken with this because he was, I was going to say, instrumental in drafting the bill. He pretty much drafted the bill, or did draft the bill. Another thing that I think I need to bring to the committee's attention, if you read the bill, there are some statements which Mr. Johnston explained to me why it's necessary that they not be in whereas clauses, but actually in the text of the bill, dealing with how we have been aggrieved, I guess you could say, by the federal government. that language is unusual language to be put in statute, and but I understand the need for it because it establishes the case for interposition. But I do want members to think about that because that would be unique. It would be something that typically we don't do. The other element of this is, and I can't speak for our Attorney General, on similar pieces of legislation, he has indicated that, I don't know what the proper phrase, he would not defend or could not defend or and those kinds of things too. Now, that's not to say that the General Assembly can't retain its own counsel. There are other avenues. But those, the three issues, I think, with the bill, the language in where you lay out the case, the fiscal note, and then defense or lack thereof from the Attorney General. So those are items for the committee to contemplate as well as we move forward. So if there's no objection, we'll move it to last calendar. And Senator Somerville, I'm happy to, but certainly it's your bill to facilitate maybe a face-to-face with fiscal review. And if Mr. Johnston can attend or be there, hopefully we can make that happen.
Well, you've been more than patient and kind, Mr. Chairman. Thank you. And thank you, committee members. I appreciate your patience with me on this. We'll keep talking because that day, as I say, is coming.
Thank you.
Thank you, Mr. Chairman. Thank you, Committee.
Thank you,
Thank you,
Mr.
Mr. Johnston.
Johnston.